I'm Dr. Stelina from South Asian University. This course is part of the Advanced Constitutional Law, and this module deals with amendment of Indian Constitution and basic structure theory. So basically in this module, what we will be trying to understand the nature and course of amendment procedure to Indian Constitution, and we will also emphasize on the basic structure doctrine and its impact on protecting the constitutional liberty of individuals. The focus of this module will be on necessity for amendment, the different kinds and procedure for amendment, the controversies regarding amendment and its relationship with fundamental rights. Then the next part, the module discussions will go on to the basic structure doctrine, its utility, its concepts and challenges, and finally the module will come out with certain conclusions and suggestions. To begin with, Constitution is the fundamental law of the land, and this is said to reflect the general will of the nations. This requirement of reflecting this general will of the Constitution is very clearly evident from the preamble of the Constitution itself, which reads, "We the people of India." As we know, the general will of the nation cannot remain as a static thing. As the nations and civilizations evolve, the will of the nations change and evolve as a response to the changing social and political conditions. So, which means the constitution of the country also has to be responsive to the changing situations, which is political, social and economical. The framers of the constitution evidently and clearly understood this requirement and inserted formally Article 368 as a procedure to amend the constitution. And if you have a look at it, the constitution, this procedure for constitutional amendment, which is given under Indian Constitution, combines both the elements of rigidity as well as flexibility. The reason being, the constitution makers understood that neither the constitution cannot be very flexibly amended according to the whims of parties, but neither the procedure should be so stringent that no amendment is actually possible. If you have a data mining of all the constitutional amendments which has taken place from the very beginning of independence, we can very safely conclude that there is very hardly few provisions of the constitution which has been left untouched. So which clearly shows that the constitutional amendment procedure which is laid down under our constitution is a combination of flexibility as well as rigidity. In fact, this requirement of the constitution being a dynamic document has been very beautifully elaborated by our former Prime Minister Jawaharlal Nehru. In his words, I quote, "While we want this constitution to be as solid and as permanent a structure as we can make it, nevertheless, there is no permanence in constitutions. There should be certain flexibility. If you make anything rigid and permanent, you stop a nation's growth, the growth of a living, vital, organic people." So this is what the constitution makers elaborately mentioned and made it incorporated as part of constitution. Now, if we come to the procedure for constitutional amendments in India, formally Article 368 of the Constitution envisages three kinds of amendment. Amendment by simple majority, amendment by special majority, amendment by special majority, as well as ratification by legislatures. So first, when we move on to amendment by simple majority, which shows that certain provisions of the Constitution, which may not be very significant in nature, can be amended by a simple majority of the parliament. For instance, issues like the size of the states, the qualification for citizenship, etc. These matters are not considered to be of vital and paramount importance. But most provisions of the constitution cannot be amended by a simple majority. Bulk of the constitutional provisions can only be amended by a special majority. And when we talk about special majority, the meaning of special majority is that an amendment has to be passed by majority of the total membership of the House and by not less than 2/3 of the House members of the House present and wanting. In fact, the requirement is that if you analyze the constitutional, majority provisions of the constitution can only be amended in this method. And lastly, another last requirement of amendment or a category of amendment is amendment by special majority. In this requirement, which is considered to be so significant for the federal structure of our polity, certain issues of paramount importance of center-state relationship, including election of president, issues regarding the judiciary, etc., comes under this category. So, and look at the three different kinds of provisions of amendment under Indian Constitution reveals that the constitutional makers envisage neither a rigid constitution but neither a totally flexible constitution. And as I already mentioned, as of now 118 amendments has been made to Indian constitutions till today, and very few provisions of the constitution remains untouched. If one analyzes the history of amendment procedure and amendment in India, one will realize that the amendment to the Indian constitution did not take much time for the constitution. In fact, the first amendment to the constitution took place as early as 1951 itself. This sudden amendment in fact has a historical reason, and if we analyze the historical reason, we understand that the freedom struggle makers, in fact, they wanted to incorporate a creation of an equitable social order as an agenda in their constitution, and they incorporated Article 39B and 39C to the constitution, which talks about creation of an equitable social order. And in order to achieve that, land reforms were introduced in various states as part of the redistribution of wealth. But Part 3 of the Constitution of India guarantees individual liberties and fundamental rights of its citizens, including the right to property. So these land reforms, which is passed in various states, were challenged in successive cases in the Supreme Court and High Court. And in the case of Sri Kameshwar Singh versus State of Bihar, the Supreme Court struck down these land reforms legislations as violative of right to property, which is a fundamental right guaranteed under the Indian constitutions. So this was an unfortunate decision which gave a setback to the social reform agenda of the government. As a countermeasure and as a reaction to this judgment, the first amendment to the constitution came into existence in 1951. Through the first amendment, 3 amendments has been made, which introduced Article 31A, 31B and 9 schedule to the constitution. Article 31A provided that any law providing for the land reforms and acquisition of property can never be challenged in the ground that it is violative of any of the fundamental rights. Article 31B gave blanket protection to those legislations which are inserted in the 9th schedule, making it beyond the challenge scope of judicial review on the ground that it is violative of fundamental rights. And 9th schedule was inserted to put those legislations which will be beyond the review of judicial review on the ground that it is violative of fundamental rights. So these 3 amendments, which is 3 articles in fact, which is incorporated as part of the first amendments, were challenged in the case of Shankar Prasad versus Union of India. The issue in this case was that whether these amendments or articles which is introduced through the first amendment, is it violative of the provisions of constitution. The petitioners on this case argued that Article 13 clause 2 of the constitution prevents legislatures from enacting any law which is violative of fundamental rights of citizens. And the term state under Article 13 is inclusive of legislatures itself. So the meaning thereby, any law which includes even amendment passed by the Parliament under Article 368 has to stand the scrutiny of Article 13, meaning they cannot make an amendment which is violative of Article Fundamental Rights and Part 3 of the Constitution. But the Supreme Court rejected these contentions. Supreme Court said there is a clear-cut difference between amending power of Parliament and legislative power of Parliament. Amending power of the Parliament is found in Article 368 of the Constitution, but ordinary legislative powers of the Parliament and its procedure can be found in Article 13. So these two things are different. You cannot combine and you cannot relate the ordinary legislative powers of the Parliament as well as the amending powers of the Parliament. So the government upheld the validity of this amendment and said the Parliament can amend fundamental rights even though it may be violative of individual rights. So this was the dictum which was followed and reiterated in a couple of cases, including the case of Sajjan Singh versus State of Rajasthan. The Supreme Court exactly reiterated the viewpoint which was held in the case of Shankar Prasad versus Union of India. So this was the dictum which is followed by the Supreme Court and approach, and as expected, the land reforms and the social welfare measures of the government continued abated. But in the case of 1967, in the case of Golaknath versus State of Punjab, and this was again challenged. In fact, in this case, an 11th bench judge of the Supreme Court took a very snooping position which was very clearly different from its earlier positions. Justice Subbarao, Chief Justice at that time, who decided this case, he came out with an innovative argument. He said, Article 368 of the Constitution does not contain the power of amendment. What we can find in Article 368 is merely regarding the procedure for amendment. So what he said is that Article 368 of the Constitution merely lays down the procedure for amendment. And if one has to look at the powers of the amendment, that can be located in other provisions of the Constitution which is dealing with legislative powers of the government. So this was a very clearly different positions which is taken by the Supreme Court from its earlier position. Secondly, the court relied on the implied limitation of Parliament's amending power. The court said the fundamental rights are very sacrosanct for the protection of individual liberty, and no absolute majority of the Parliament can change or alter that composition. And Supreme Court noted that, in fact, if anybody in the governmental structure has the authority to amend the fundamental rights, it can be only done by the Constituent Assembly, which means the Parliament has no power to amend the fundamental laws or fundamental rights of the citizens. So this was a setback which was given to the government and to their social reform agenda, in fact. And this had an immediate fallout politically because the government could not fulfill their social reform agenda and they suffered massive in the elections. So the government come out with more amendments and in fact more legislations in the form of nationalization and privy purse, which both obviously affected the right to property. So these decisions were also obviously that challenged the Supreme Courts, and this courts very elaborately and discussed and accepted the viewpoint which is there in the Golaknath case and dismissed these cases and obviously struck down these legislations as violative of fundamental rights. So in order to neutralize the effect of Golaknath case, the Constitution amendment, in fact not just one, various amendment has been brought into Constitution in the form of 24th Amendment, 25th Amendment and 29th Amendment. In fact, if you look at that, 24th Amendment, 25th Amendment and 29th Amendment has really broadened the scope of amending procedure under Article 368. 24th Amendment clearly clarified that the limitations under Article 13 Clause 2 of the Constitution in relation to fundamental rights will not be applicable to an amendment which is made under Article 368 of the Constitution. And 25th Amendment has made it very clear that directive principles of state policy will have precedence over fundamental rights. In fact, this was a completely different viewpoint which is taken from the earlier decisions and also in fact the constitutional mandate, whereas it was always believed that fundamental rights has a supremacy over directive principles. And 29th Amendment in fact further enlarged 9th schedule by adding some of the Kerala land reforms legislation to its list to make it non-accountable to fundamental rights. all of these amendments were in fact challenged in the classic and seminal and fundamental case which changed in fact the course of Indian polity in the historical case of Keshavananda Bharati versus State of Kerala. So, in this case, not only these amendments were challenged, in fact, this case marks a turning point in the Indian political history. This Keshavananda Bharati versus State of Kerala. This is the largest bench, 13 bench judges heard this particular case. In fact, this was the largest number of judges heard a particular case for the first time in the Indian history. And they upheld the validity of 24th Amendment, which said the limitations of Article 13 Clause 2 will not be effective in terms of amendment to Constitution under Article 368. But there was a lot of discussions and debate took place in that particular case regarding the scope of amending procedure to Indian Constitution. So, in this case, for the first time, the Supreme Court of India has brought about this innovative concept of basic structure doctrine. They accepted that by a 7-6 majority, the Supreme Court of India accepted that yes, Parliament has the power and procedure which is laid down under Article 368 of the Constitution to amend the procedure, but these powers of the Parliament to amend the Constitution is not absolute, it is limited. It is limited by something known as the basic structure doctrine. So, what they contended is that unlike the Golaknath case, which laid down that Article 368 lays down only the power of the procedure for amendment, in Keshavananda Bharati, the judges very categorically made it very clear that Article 368 contains not just the procedure, but also the power of amendment. But that power of amendment is not limited, it is not absolute, it is limited by what is known as the basic structure doctrine, meaning there are certain essential and fundamental features to Indian Constitution that cannot be abrogated and amended even by an absolute or a special whatever the majority. The Parliament is incapable of amending what constitute a basic feature to Indian Constitution. In this historical case of Keshavananda Bharati case, Advocate Mr. Palkiwala had argued for the petitioners and appeared on behalf of them. He argued certain very important points. He said the meaning of amendment can be three things. One, to improve or better the Constitution. This improvement or betterment is in relation to the Constitution underlying philosophy, meaning thereby the basic underlying philosophy cannot be changed and altered, it can only be improved. Secondly, yes, to make an alteration or to remove an error. But even this will not touch upon the essential features of Indian Constitution. And lastly, yes, the Constitution has, the makers has the power, the Parliament has the power to amend all provisions of the Constitution. So, he contended that the last requirement that the Parliament has the power to amend all provisions of the Constitution cannot be a valid one. When we talk of amendment, it can only mean the first and second category, that is to remove an defect or remove an error or to improve the basic philosophy of the Constitution. But when the Parliament undertakes this process, it is under an implied limitation that they cannot touch upon the essential and basic philosophy of the Constitution. And this viewpoint has been accepted by the Supreme Court judges, and in fact in their words I quote, "Since the Constitution had conferred a limited amending power on the Parliament cannot under the exercise of that limited power enlarge that very power into an absolute power. Indeed, a limited amending power of the Constitution Indeed, a limited amending power is one of the basic features of our Constitution, and therefore, the limitations on that power cannot be destroyed. In other words, Parliament cannot under Article 368 expand its amending power so as to acquire itself the right to repeal or abrogate the Constitution or to destroy its essential features. This is a limited power and cannot by the exercise of that power convert the limited power into an absolute one." This is the quotation from the Keshavananda judgments. But the problem was that judges did not have any clarity consensus regarding what exactly constitute the basic structure of Indian Constitution. The judges came out with their own interpretation. Justice Sikri, who has given the majority judgment, has said supremacy of the Constitution, separation of powers, republican form of government, secular character of the Constitution, federal character of the Constitution constitute the basic structures. Whereas Justice Shelat and Justice Grover said welfare state on the basis of equality, unity and integrity of the nation constitute basic structure. For Justice Hegde and Justice Mukherjee, sovereignty of India, democratic character of the nations, unity of the country, these elements constituted the basic structure. This basic structure doctrine was definitely reaffirmed because this was a historical point in the Indian political history. In fact, many people say that Indian judiciary saved the Indian Constitution from the parliament autocracy. In fact, Professor Upendra Bakshi and V.N. Sukla says that judiciary has got a say in the constitutional amendment is a unique feature of basic structure. And the later post Keshavananda Bharati scenario, what we can see is that the Supreme Court in a catena of cases actually reiterated the positions which is laid down in the Keshavananda Bharati case and upheld and in fact expanded the list of basic structure doctrine. In fact, soon after this Keshavananda Bharati judgments, we definitely got an occasion to test the validity of this doctrine in the very famous case of Indira Gandhi, Nehru Gandhi versus Rajnarayan. That was a case regarding the election of the Allahabad judgment's decisions invalidating Indira Gandhi's elections and the subsequent amendment of that. The issue at stake was the 39th Amendment, which removed the power of Supreme Court and other courts to adjudicate on matters regarding the elections of President, Vice President, Prime Minister and Speaker of Lok Sabha. While upholding the validity of 39th Amendment, Supreme Court has reiterated the essential elements of basic structure doctrine and expanded the list of basic structure doctrine. In specific, they have said judicial review constitutes one of the basic structure of Indian Constitution. They further elaborated democracy, the judicial review, republican government, federalism, equality and rule of law constitute basic structure. So, in fact, after this Rajnarayan cases, all the cases, in fact, catena of cases has categorized and expanded this basic structure doctrine. Again, in the case of Minerva Mills versus Union of India, the 42nd Amendment, which expanded the scope of amendment, was challenged. The court held that since the Constitution had conferred a limited amending power on the Parliament cannot, under the exercise of that limited power, enlarge that very power into an absolute power. In fact, what they said is that limited amending power itself is a basic structure to Constitution and that limited amending power cannot be converted into an absolute amending power. Further, they also said neither directive principles has a primacy over fundamental rights, neither fundamental rights has a primacy over directive principles. In fact, the harmony between directive principles and fundamental rights are one of the basic structure of Indian Constitution. The further cases, in fact, elaborated more on the basic structure doctrine. In the case of S.R. Bommai versus Union of India, the federalism, democracy and secularism was declared to be basic structures. In the case of L. Chandrakumar versus Union of India, judicial review was declared to be a basic structure. In the case of I.R. Kohallo versus State of Tamil Nadu, judicial review was again declared to be basic structure. In this case, the Supreme Court said all the amendments and all the legislations which has been made after the judgment of Keshavananda Bharati and all the articles, all the legislations which has been inserted in the 9 schedules can be challenged if they are violative of article fundamental rights of Constitution, or other words, all the legislations inserted in 9th schedule has to stand the scrutiny of fundamental rights post the Keshavananda Bharati judgments. So, as we know today that the basic structure doctrine has lent a lot of durability and coherence to Indian Constitution. It has withstood the time, and after 1972 the Supreme Court has on many occasions has tried to control the unbridled exercise of amending power of parliament. But in this context, we need to have a look at what constitutes the basic structure doctrine, what are the historical facts which prompted the Supreme Court of India to bring about these innovative conventions. In fact, if we look at the basic structure doctrine, the genesis of the basic structure doctrine in India can in fact be traced to the academic circles to a lecture given by German scholar Conrad in 1965 in the limited implied limitations of the amending power. In fact, what he said is that basic structure is a doctrine which can give a lot of coherence and durability to constitution, which has very intrinsic values, and this has to come into existence in some form in various times in the political history. In fact, he said amending power of parliament can never be absolute. Howsoever worded, even if Article 368 starts with that parliament can amend any provisions of the constitutions, meaning explicit words of Article 368 does not contain any limitations. So, but what he contended is that whatever may be the terminology, whether it is flexible, whether it is rigid, whether it is absolute or limited, parliament can never be given an absolute amending power. For his arguments, he has given a hypothetical situations. He said, can any parliament, especially in the context of India, can the Parliament of India by an absolute majority amend the constitution article 1 and say that India is divided into two? No. The obvious answer will be no, which means that whatever may be the wording of article 368 implied limitation. Professor Conrad in his lecture observed that no parliament in the world can have an amending power which is absolute. Whatever may be the wording of provisions which is relating to amending procedure, whether it is absolute or limited, amending power can only be limited in nature. He has given various examples regarding the amending limitations of amending power. So, the underlining point of Professor Conrad is that the amending power of parliament which is given in any constitution can never be absolute but can only be limited in nature. And in fact, it is this viewpoint that has been first argued in the case of Golaknath basis by the advocate N.K. Nambiar, but it was obviously at that time rejected, but later found its favor in the Keshwananda Bharati judgments, where the judges felt that the parliament can never have an absolute amending power. From where did the Supreme Court judges found out this innovative doctrine, which is now has found favor in all academic circles and in all the cases? Explicitly, if you look at Article 360 of the Constitution, Article 368 very clearly says that Parliament can amend all provisions of the Constitution. So, there is no explicit limitations which is laid down by the constitutional provisions on the amending power of Parliament. Neither the Constituent Assembly debates shows that the Constitution framers intended any sort of limitations on the amending power. So, what is the contention is that we are not able to actually found out from where does this doctrine particularly originated in the mind, except in the academic circle by a lecture and the Professor Conrad. Obviously, yes, he laid down the importance of implied limitation and not on the absolute limitations power of parliament on amendment. If we analyze the basic structure doctrine, it's very difficult to find out how come the Supreme Court judges actually found out this doctrine. As pointed out, Article 368 of the Constitution nowhere explicitly mentions the limitation of Parliament's amending power. 368 of the Constitution in fact says Parliament can amend all provisions of the Constitution. Similarly, even the Constitutional Assembly debates neither points to the framers' mind that they had something in their mind regarding implied limitations on Parliament's amending power. But the Supreme Court judges, following the academician Conrad's opinion, found out that Parliament's power to amend Constitution is limited but not absolute. The Constituent Assembly debate also gave no indications of such a doctrine being part of the constitutions. But it's now today accepted that this doctrine of basic structure is part of Indian Constitution. In fact, what is meant by constitutionalism today mostly revolves around the debates of basic structure in fact. And if you look at the utility of this basic structure doctrine, yes, this has definitely provided a sort of permanency and durability to protect the very core of the Indian Constitution. And in fact, without this doctrine, perhaps the Parliament would have continued with its unbridled exercise of amending procedure to the Constitution. And in fact, the shortcomings and drawback of such an approach we have seen in various cases, including the 38th Amendment and 39th Amendment, where the Supreme Court has been precluded from looking into the elections of President, Vice President, Prime Minister and Lok Sabha, to name a few. So, the basic structure doctrine basically has saved the country at turbulent times, and it has tried to protect the individual liberties. But certain questions still linger. In this, all the concept of doctrine of basic structure, basically if India looks at the basic structure, India follows a federal structure with division of powers between center and states, and also different organs of the government. But in this all process, judiciary has come out as the most powerful wing of the government. But is judiciary always free from errors? We cannot answer. What if the judiciary has erred in making a particular feature as a basic structure? Who will correct that? We don't have any answer obviously to that. Secondly, even to look at the fundamental principle of basic structure, when we contend that at one point that Constitution is the fundamental law of the land, can there be some provisions which is more significant, some provisions which is less significant, and who is to find out what are the features which constitute fundamental? And moreover, is there any fundamental principles which will be fundamentally remaining for all course of time, which will never be changed? For instance, take a case, India follows the parliamentary form of democracy, but for a long time there was a lot of debate on shifting it to a presidential form of democracy. But in various cases, Supreme Court has obviously said that the parliamentary form of democracy constitutes one of the basic features of Indian Constitution. Does that mean India can never convert to a presidential form of democracy? So if that is the case, then we stop a nation's growth. So my contention is that, is there any basic structure which you can actually call it permanently basic for all long to time? Secondly, on a more fundamental level, what exactly constitute basic features of the Indian Constitution? Even if you look at the Keshavananda Bharati judgments, judges did not have any clarity and any consensus. Various judges, in fact, from the Justice Sikri, Justice Shela, Justice Grover, they all came out with their list of basic structure. And another point which is to be noted in this, all the post Keshavananda phases, all the judgments which is consolidated and expanded. And in fact, if we look at the features which constitute the basic structure is on increase. In fact, in the case of I.R. Kohala versus State of Punjab, in that case where the Supreme Court has said judicial review constitutes a basic structure, and they also said all the legislatures which has been inserted in 9th schedule post Keshavananda Bharati judgment day will have to stand the test of scrutiny of fundamental rights. In that case, they said Article 14, Article 15 and Article 16 of the fundamental rights that also constitute basic structure of Constitution. So, what the contention is that there is no clarity regarding the contents, contours regarding the basic structure, and this list is actually not ending and it is not exhaustive. In fact, it is expanding in fact. So, there may be a time will come, most of the provisions of the constitutions will be declared to be fundamental rights and Parliament will not have any authority to amend these provisions. So, this approach actually in fact can be very, very dangerous. In fact, various jurists and authors has looked into this, the critical aspects of basic structure doctrine. In fact, Sherbai, one of the most constitutionally celebrated expert in his book, has elaborately dealt regarding the basic structure doctrine. So, he pointed out, in fact, he pointed out two aspects regarding basic structure which is very, very relevant to these discussions. So, he pointed out, yes, definitely there may be certain essential features which constitute basic structure to Indian Constitution, but at the same time there are certain features which is very, very significant, but that may not be constituting the basic structure. So, can you say that okay, only that basic structure features which is important, other features which is very significant for a center state relationship or even a federal structure, is less important? The answer is not very easy. For instance, in the case of Free Berubari, the Supreme Court said the Parliament through amendment can even cede a territory of India, but that does not violate a basic structure. How can that be possible? The Parliament has been given the power and authority to part with the territory of India, and we contend that that cannot be violative of basic structure of the Constitution. So what the contention of the Shirva is that, yes, there may be certain essential features, but there are various other significant features of the Constitution that also is very, very important. So where do you draw the distinction between basic structure and non-essential features of the Constitution? It is not very, very easy. But at the same time, that does not actually deviate or negate the validity of basic structure doctrine, because one of the negative arguments which is raised often in the context of basic structure is that the contours on the dimension, the contents of basic structure is not very, very clear. But as Dr. Shirvai contends that there are various features under the law which cannot be defined with precision, and there is no requirement to be defined with precision. For instance, the concept of natural justice, the concept of negligence, the concept of reasonableness, all these legal concepts we can never define with 100% of clarity. So even though basic structure cannot be defined with 100% of clarity, there is definitely a consensus among the jurists and academics of this country that yes, there are certain core features of the constitutions that remains the basic. So that is the essence of basic structure doctrine. So in conclusion, actually we can say that yes, the basic structure doctrine has been brought into Indian polity in order to check the unbridled arbitrary exercise of amending power by the Parliament, and also in order to safeguard and protect the individual liberties of the vulnerable citizens of the country. And to an extent, the judiciary has succeeded in that attempt through the basic structure doctrine. So the basic structure doctrine has actually stood the test of time, and we cannot today argue that the basic structure doctrine is not relevant. So in this regard, there are 2 points which is very, very important. The amending procedure of the Constitution is very, very important. As in the beginning of the module, it has been made clear that Constitution is not only a political document, it's a living social document which has to be dynamic and which has to change with the changing aspirations of the people according to the political and social needs. So the Constitution has to change. In fact, if you look at the Constitutional Assembly debates, where Mahavir Tyagi has said that if any constitution is made difficult to be amended, or in fact if there is no provisions for amendment in the Constitution, and that is a violation which is committed on a future generations. So this shows the importance and relevance of having a dynamic constitutional amendment procedure, which should be neither very flexible, which should not be very rigid in fact. So what we require is a balance, and basic structure doctrine has tried to incorporate that balance into the unbridled exercise of possible arbitrary exercise of amending by the Parliament. In fact, to an extent they have succeeded in that attempt. A question arises, if Parliament cannot amend constitutional, which authority can amend constitution? Judiciary is not empowered with the power to amend constitution. So this fact we have to keep in mind when we promote the basic structure doctrine. See, there is no doubt regarding the validity of basic structure in its role in protecting the individual liberty. But in order to balance the power of Parliament to amend the constitution and to protect the constitutional liberty, and also to check the arbitrariness associated with the judicial decisions in expanding perhaps the basic structure doctrine, the possible method can be done in the way as done by Germany. In that Germany, what they have done is that it's from the Germany in fact this basic structure doctrine has been originated. So they have made an amendment to Constitution of Germany that whereby they have explicitly and exhaustively listed the basic structure to their constitution. So these provisions cannot be amended. So what the Parliament can do is that they can, through the consultations and through the academics and judiciary, can come out with a list of basic structures and can make it part of the constitutions as formally. So once for all, like there can be a clarity regarding what constitute actually basic structure. So this way, the basic structure, the contours and consensus, there will be a consensus on what exactly constitutes the basic structure, and this doctrine will be available as a guiding light to amend for the parliament to amend the constitutions. So like what we have to understand is that constitution of any country is considered to be very sacrosanct and foundational, and this has to be always reflective of the general will. But to be reflective of the general will, that obviously changes with the political situations and social situations. This amendment has to be there, but at the same time there are certain core values on which any constitution is based that cannot be amended by even absolute majority, and that is what in nutshell the basic structure doctrine tries to protect. The purpose of this module was to understand the nature and scope of amendment procedure, the basic structure doctrine and its controversy and its role in protecting the fundamental liberties of individual. So by the end of this module, we have discussed the structure, the procedure of amendment, the chronology and the history of amendment, various amendments, the controversies associated with it, and also obviously the significance of amendment procedure in the constitution. We have also discussed the basic structure doctrine, how it has originated, what is the role of basic structure in protecting or having a check on the amending power of parliament, and also in protecting the liberties of individual. So this was what we intended. Thank you for your attention.